You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 38, Pros and Cons of Filing a U.S. versus a PCT application first. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or if that's too hard to remember, you can get to it through patentingforinventors.com, that's patentingforinventors.com, or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. This is going to be the last episode for now related to foreign patent applications. So far, I've covered what a PCT application is, how they differ from U.S. applications, how to file a PCT application, timelines and deadlines of PCT applications, and how to file in non-PCT countries. In this episode, I'm going to talk about something that I've made reference to several times throughout the podcast, and that's whether to file a PCT application first or a U.S. application first, and why you might want to do one versus the other. Remember, in a PCT application, you file a single application, and you could use that application to enter patent offices in most countries throughout the world, generally within 30 months of your earliest filed application, including the United States. Also, remember that you can file a U.S. application, and then within 12 months, file a PCT application, and then 30 months from your U.S. application date, enter into most countries throughout the world. Since one of the countries you can enter from your PCT application is the United States, why don't you just file a PCT application first, and then you have 30 months to file in most countries throughout the world, including the United States. Why bother with filing a U.S. application first at all if you can do it later with the rest of the countries? And actually, a lot of people do this. They file a PCT application first, and then enter the United States later. But why would someone choose one versus the other option? And that's what I'm going to talk about here, the pros and cons of doing either a U.S. application or a PCT application first. There are probably 4 main considerations and a few minor ones: countries you're interested in, money, information you'll get at specific times, and how many versions of your invention you have in your application. Some of these are tied together, and there's no one right answer for everyone because every person or company has to weigh these different factors based on their own circumstances. Let's talk about countries first. If you know that you're only interested in getting a patent in the United States, there's no reason why you would need to file in any other country, so you wouldn't file a PCT application. So you file your U.S. application first. But let's say you're pretty sure you only want to file in the U.S., but there's a small chance that you might want some other countries later. In this situation, you might still want to file in the U.S. first, and then by the time 12 months comes around, you can file a PCT application. But let's say you were pretty sure you only wanted the United States, but you filed a PCT application first. In this situation, you file your PCT application, pay all the fees for the PCT application, then 30 months later, you file your U.S. application and pay more in U.S. application fees. Basically, you just paid for 2 applications when all that you really cared about was getting a U.S. application, so you spent more money than you needed to. If you think you're going to file in numerous countries throughout the world, this leans in favor of you filing a PCT application first, and this will make more sense once I go over the other factors you want to consider. If you're thinking about maybe filing in 1 to 3 countries outside the United States, maybe you don't want to do a PCT application at all, and you just do a U.S. application and file directly in these foreign countries later. Once you're past probably around 3 countries, a PCT is generally going to be the route to go. Let's talk about cost. PCT applications are generally more expensive to file. It depends on the size of the application, but filing fees typically could be between $2,000 and $3,000 more for a PCT application compared to a U.S. application. It doesn't really take any more time or energy to prepare a PCT application compared to a U.S. application, so the added costs are not attorney's fees, they're just official filing fees. So if a U.S. application costs around $7,000, a PCT application might be around $10,000. And this really isn't due to the attorney getting any more money, it's just due to those fees that are due when filing a PCT application. So if you're really short on money and can just afford the bare minimum and want to get something on file, you might file a U.S. application first. Then 12 months down the line, you'll have to pay more money if you want a PCT application, but at least you spread your cost out a little bit in the beginning. If you're someone where a few $1,000s doesn't make a difference, that probably would lean in favor of filing a PCT application first, or if it doesn't lean in favor of PCT, it just doesn't lean in favor in any direction, and you would just consider the other factors. Now let's look at the information you get. It's somewhat unknown when you'll get an opinion from the U.S. Patent Office about the patentability of your invention. Oftentimes it's more than a year. If you do a PCT application first, you should get your international search report and opinion usually by 10 or 11 months when you get your opinion on the patentability. So you should have a decent opinion about the patentability of your invention before 1 year if you file a PCT application. And that can help you if you want to file in non-PCT countries by the 12-month mark. If you file in the US first, you might not get an opinion within 12 months. And at that 12-month mark, you have to decide whether to file a PCT application and file in non-PCT countries. So the information you get by doing a PCT first weighs in favor of a PCT application. There's not really any information you get by filing a US application first that would make this weigh in favor of filing a US application first. Maybe there is, but I actually can't really think of one. Another advantage of cost and timing and information you get altogether is that if you file a PCT application first, if you then want to file a US application and you receive a report from the International Searching Authority that your claims are patentable, then you can get reduced fees when filing your US national stage. Also, you can get your application examined quicker if you already have claims that were found allowable by using something called the Patent Prosecution Highway. This is a program where if your claims are found allowable by one searching authority, oftentimes you can get your application fast-tracked in the United States. I'll probably do a whole episode later on the Patent Prosecution Highway. Plus, even if you don't use the Patent Prosecution Highway, under the Federal Code of Regulations, it says that a U.S. national stage should be taken out of turn for examination. This means that, let's say there's a 2-year backlog for regular U.S. patent applications, that in theory, according to the federal rules, your national application that came from a PCT should get examined quicker. So you might even be able to get a U.S. patent faster in some situations if you filed a PCT first and then a U.S. application if you did that quickly, compared to if you just filed a U.S. application. There are advantages to filing a PCT application first, but if your number one priority is getting a U.S. patent application issued as quickly as possible, you probably want to file in the U.S. first and pay for Track 1 prioritized examination, which I talked about in a previous episode about how to get your application examined quicker. Another timing issue is that if you file a PCT application first, you don't have to worry about filing any more applications for 30 months. Instead of if you do the U.S. application first, then 12 months down the line, you have to worry about whether you're going to file a PCT application. Now, this only applies to PCT countries, though, because you still have to worry about non-PCT countries 12 months down the line for either a PCT or a U.S. application. There is one other scenario to think about that should weigh in your decision, and that's if you have multiple related inventions in your patent application. As a general rule, you're only supposed to have one invention per application, but you can have different versions of your invention and not really have them count as separate inventions. The standard for what counts as a separate invention that requires different applications or paying extra fees for multiple inventions is different in the US versus the PCT. In theory, it should be a little bit easier sometimes to put in multiple inventions into a PCT application. So the advantage of filing a PCT application first is that if you have multiple inventions, you may be able to keep them in the PCT application and just pay a single invention fee. And when you enter into the United States from that PCT application, the US should use the PCT standard and not the US standard for multiple inventions. So in theory, if you file a PCT application first and then enter the US, in some situations, you may have to pay fewer fees down the line because your US application will stay together as a single invention application instead of being required to split the application apart into what are called divisional applications. I haven't seen any statistics to see if it's really true that national stage US applications have fewer divisional requirements than US applications that are filed first. So this could all be theoretical, but it might be something to consider if you have an application that has lots of versions of an invention. And if you're on the fence about filing a US versus a PCT first, this might sway you in favor of a PCT application first. One other thing to keep in mind is whether you filed a provisional patent application in the United States. There is no PCT provisional application. The question is whether you should file a US non-provisional application within 12 months of your provisional or a PCT application within 12 months of your provisional. You should probably use the same factors in determining which one is better for you that I just went over. And remember that the date that you want to start tracking things, such as the 12-month and 30-month deadline, they start from your provisional application filing date. So as a review, let me give you some rules of thumb for why you might choose one over the other. If you're pretty sure you're only going to file in the US, file in the US first, and if you change your mind later and want some foreign applications, then file a PCT application second. If you're really short on cash and a few $1,000s makes a difference, then file the US first and then file the PCT second. The opposite scenario is if you know you're going to file in a lot of foreign countries, including the US, file the PCT first and then the US and other countries later. If a few $1,000s aren't going to make that much of a difference, then probably file a PCT application first. If your number one priority is getting a US patent issued as quickly as possible, you probably want to file a US application first with track 1 priority, but there are still ways to get your application examined quickly, even if you file a PCT application first, so this probably shouldn't weigh too much in either direction. And lastly, if you're on the fence about what you should do and you have multiple versions of your invention, then you might want to file a PCT application first because of the requirements for multiple inventions getting split up or having to pay more fees in a US versus a PCT application. So this was the last episode for now about PCT applications. There are lots of aspects I didn't cover, such as how to actually make amendments in a PCT application, how to argue for patentability, and I'll probably cover those in later episodes. Many of you won't be interested in foreign applications at all, but I want to go over some introductory topics because if you do file in the US, you only have 12 months to file a PCT application, and you should be aware of what you're getting into to do that. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com, that's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.